Okay, good afternoon ladies and gentlemen. Welcome to People Hour. My name's Simon Horsfield, one of the partners in the Employment and Pensions team here at gunnercooke. So for those who aren't familiar with the People Hour format, we will speak for no more than 1 hour, so we'll definitely be finished by 2 o'clock. I will take you through the slides. I've got a set presentation. And I think we'll just take questions as we go. If you look on your screen, you'll see that there's a question raising facility. If you type your question in as we go, if I spot it, I'll pause the presentation, try and deal with the question, and then we'll move on. Great that you've dialed in to listen to the presentation live. After this session, we will put the recording along with the slides onto our website, so if there's anything you miss, you can go back and listen to it again, or if you've got colleagues who couldn't dial in live, they will be able to at least listen to it after the event. So without further ado, we will start the presentation. And in today's session, I wanted to really focus on these things that are on the slide: holiday pay and commission. It's a burning issue, so let's take stock, see where we're up to and see what practical steps we should be taking to deal with that particular issue. I wanted to give an update on 0 hours contracts. I wanted to talk about varying contracts of employment, and particularly varying contracts relying on a general right to amend that might be built into the contract of employment. We'll then have a look at unfair dismissal and what lengths an employer has to go to be comfortable that they've conducted a reasonable investigation into someone's misconduct. And then we'll bring the session to a close by looking at recent tribunal statistics and some learning points that we can take from the way tribunal statistics are coming out at the moment. So we'll start with holiday pay and commission, and the case I'm wanting to focus on is Lock and British Gas. And the key issue that this case addresses is whether holiday pay should take account of what an employee earns through commission in addition to their basic pay. And I should just say I'm talking about statutory holiday here, not any enhanced company holiday. So, under the working time regulations, workers with normal working hours have their holiday pay calculated by reference to their basic salary for those normal hours. And Mr. Locke was one of those people who had normal working hours, 9 to 5:30, Monday to Friday, or whatever it was. And so because that was what the contract said about his hours, and because of the way the working time regulations are drafted, British Gas didn't factor into his holiday pay calculation any of his commissionable earnings. So his holiday pay was calculated by reference to his base salary only. And British Gas aren't alone in that. That's, in my experience, that's the way most of the UK employers have traditionally approached this issue. So the effect of this for Mr. Locke was he went on holiday, had a 2-week holiday over Christmas, going back to Christmas 2011, and he was paid his holiday pay calculated by reference to base salary. Now, at the time he took the holiday, because of the way the commission scheme worked, he actually benefited from commission payments that fell due during that period. So when he took the holiday, he suffered no immediate drop in income. The problem he encountered, though, was that because he didn't make any sales during that 2-week holiday period, he suffered a drop in income in subsequent months when the commission would otherwise have been due had he been around over that Christmas period to make the sales. So it's all to do with that lag between when the sale is made and when the commission is paid. Now, because he'd suffered that drop in income, he brought a claim in the Employment Tribunal, and he said that British Gas were in breach of the working time regulations in relation to the way they'd calculated holiday pay. He said his holiday pay should have included an extra amount to compensate him for the commission that he'd lost out on while he took that annual leave. Now, the tribunal that looked at this decided to refer the matter on to the European Court because, of course, our working time regulations stem from the Working Time Directive, the overarching European legislation. So it's the European Court that can make decisions on how the UK should have implemented that directive. And what the tribunal asked was, very simply, should commission payments be taken into account when calculating holiday pay? And the European Court held that yes, they absolutely should. And the reason the court held this was that the purpose of the Working Time Directive is to ensure that workers are at liberty to take annual leave without the pressure of losing pay. And that's all really because the Working Time Directive is principally seen as a piece of health and safety legislation. It's in the interests of employees' health and safety to require them to take annual leave. So anything that's seen as a deterrent to people taking annual leave is frowned upon and unlawful under the Working Time Directive. So the European Court held that pay in this context should include the commission that the employee would otherwise have earned had they been working. And they said if that doesn't happen, if we exclude commission from the definition of pay, as is the case under the Working Time regulations, then this quite simply acts as a deterrent. So it has the potential at least to stop workers from taking their holidays. So that was the decision of the European Court, but we're then left in a difficult position because the Working Time regulations clearly don't do what the Working Time Directive requires them to do. And most employees in the UK can't issue a claim purely on the basis of the wording of the Working Time Directive because that's European legislation, doesn't have direct effect. They can't rely on it unless they work in the public sector, and clearly that wasn't the case for Mr. Locke. So what he had to do was wait for the case to go back to the Employment Tribunal for them to work out how on earth do they interpret that decision and apply it in the UK context. And that's the case that we've had just this last month or so. And before the tribunal, British Gas argued that the wording of the Working Time regulations is absolutely clear on this point, and I have to say I agree with them, and that it's not for a tribunal to rewrite the wording of the Working Time regulations. If the Working Time regulations have been enacted improperly and they're incompatible with European law, then that's an issue for Parliament, and Parliament has to sort it out by drafting a new set of regulations. And that was very much the thrust of British Gas's case at the reconvened tribunal hearing. But, not for the first time, the Employment Tribunal disagreed and argued that it was within their ambit to construe the Working Time regulations in a way that's compatible with the European Directive. And as I say, that's not the first time we've seen tribunals really stretching this rule of interpretation to remove any incompatibility with European legislation. And the way they did this was to find that a worker who has normal working hours but earns commission should be deemed to be the same as a worker who doesn't have normal working hours and whose pay therefore varies according to the amount of work done. And the significance of that, when you track that through in terms of the Working Time regulations, is that there are then different approaches to calculating holiday pay, and for the worker who doesn't have normal working hours and whose pay varies, it's an averaging out process, which we'll come on to in a moment. And so the outcome of that tribunal decision is that commissionable earnings do now have to be included in holiday pay, and in fact always should have been, again a point we'll come on to. Perhaps slightly unhelpfully, the tribunal didn't, in this instance, determine the amount of holiday pay or indeed pass any comment on what reference period you use for the purpose of averaging out somebody's commission entitlement. But that will fall to be determined at a future hearing unless the parties reach an agreement in the meantime. But I think the key point is, if we follow through the logic of the working time regulations, which takes you to section 221 of the Employment Rights Act to work out how you calculate a week's pay, then it seems clear that the reference period will be a 12-week reference period. So at the date someone starts a period of annual leave, you'll have to average their earnings, including commission earned, over the preceding 12 weeks to determine what their holiday entitlement should be, and their holiday pay should be, rather. Now, if you just follow through the logic of this, in the context of commissionable earnings, the impact for the individual employee is going to be that they're going to receive a pay bonanza when they take their holiday, because they'll get their basic pay, they'll get the commission that falls due for payment that they've earned 2 or 3 months previously, but on top of that they'll be getting a commission advance to compensate them for the commission that they're going to miss out on in 2 or 3 months' time. Now, it could be argued that that doesn't actually remove the deterrent to take holiday pay, because the individuals will still be suffering that drop in income in 2 or 3 months' time. But the way the tribunals kind of rationalise that is to say, well, at least they've had the advance, they can store that money up, and then they can use it when their earnings do drop. So I think that's the principle that applies. So what does this mean for us? I mean, I don't think any of us will have been surprised that this was the way the tribunal approached things, and it's certainly consistent with the cases we've looked at in previous webinars, and I'm thinking of Bear and Fulton on overtime and holiday pay, and it's all to do with this concept of an employee being entitled to normal remuneration during periods of statutory annual leave. But I think if you've not done so already, what I would certainly be recommending is an audit of the business to determine just what this holiday pay risk is, if indeed there is a risk within your business. And I think, as well as looking at commission entitlements, we should also be factoring in overtime payments and indeed any other allowances, so shift allowances and the like, which do affect people's pay and do constitute normal remuneration. There is clearly an issue here with back pay, because of course we're not talking about a change in law. What we're saying is the way the law has been interpreted thus far is incorrect, and so on the face of it, employees have the right to put in back claims. You'll all be aware of the principles under the unlawful deduction from wages part of the Employment Rights Act, and the fact that people can go back indefinitely, in theory, treating this as a series of deductions. Some good news there, in that new regulations are coming out in July, which will place a backstop of 2 years on claims for back pay by way of unlawful deduction from wages. But of course, that's claims that are brought on or after, I think it might be the 1st of July, I can't remember the date off the top of my head, 2015. there remains therefore this significant window of opportunity for employees with back claims to put in claims now, and I'm certainly seeing trades unions getting quite excited about this issue. Certainly one of my clients has had a letter from the regional officer of the union saying, what are you proposing to do about holiday pay? And it's clearly something they are gearing up to tackle, and they will be tackling before that backstop is enacted in July. So I think we need to be ready for the fact that there could well be some significant back pay claims, and I think really we need to be, if we've not done so already, letting the business know about the issue so that provision can be made, and deciding on a strategy. Now, what the right strategy is, I can't say via a webinar because it will very much vary from employer to employer. But suffice to say, if you haven't yet worked out your strategy, then I think you need to do so, and you need to be taking legal advice on this issue, because it is a serious issue that's very real and out there. Okay, so that's all I wanted to say on holiday pay and commission. We've had a question come in, so I'm just going to see if I can access that. So the question is, do we only need to pay back pay if employees request it, or are we obliged to do it automatically? Now the answer is, you're not obliged to do it automatically. Clearly the liability for back pay is out there, but if you can reach an agreement with the employees along the lines of correcting things from this point and changing future practices only, and they don't think to put in a back pay claim and you get away with it, then as long as you've broken that chain in the series of deductions by more than 3 months, then they're not going to be able to go back and put in the back pay claim. So effectively, if you can do it and no one spots the issue and you get away with it for 3 months, then you'll be safe. Next question is, does this only apply if the overtime is contractual? The principle is capable of applying to voluntary overtime just as much as it's capable of applying to compulsory overtime. It's a question of what constitutes normal remuneration. So if the overtime is part of their normal remuneration because it's regularly worked, even if that's on a voluntary basis, then it's going to need to be addressed as part of your strategy. And then we've had a further question through. This is to do with hourly paid employees. Some who work overtime regularly, some who work overtime irregularly. So some are working 45 hours contractual. So it seems that there's a whole range of different practices. I think the key thing where you've got hourly paid employees is to determine if their pay level of remuneration varies according to the hours that they've done, then you're already into this 12-week averaging out process for determining their holiday pay. So if you're not doing that already, then on the face of it, I think you should be. If you're treating them as having normal working hours and only paying them by reference to base salary, then I think you're looking at very quickly at this question, it looks like you're going to be exposed. But that might be something we just have to take offline. So by all means, do pick up that question either with me or your usual advisor, and we can look at that one in a bit more detail. Okay, I'm going to carry on with the presentation. And I'm going to move on to 0 hours contracts. And we have an issue here that potentially exclusivity clauses in 0 hours contracts are going to be banned. And 0 hours contracts, just by way of reminder, are contracts that oblige a worker to accept work when it's offered, but don't give any guarantee that any work will be forthcoming. And I used to certainly refer to these as casual as and when required contracts. So very much the kind of thing that you use with your casual workforce. Now what we've seen is a practice develop where these contracts include a provision stopping the worker from working for any other third party. So essentially they're at your beck and call the whole time, also known as an exclusivity clause. And after quite a bit of pressure, the government has proposed to outlaw exclusivity clauses and has published a draft set of regulations. There was a suggestion that 0 hours contracts would be outlawed altogether, but I think the government recognises that actually 0 hours contracts are quite popular with workers just as much as they are with employers. So the way these regulations work is to include anti-avoidance measures. And one of the most obvious ways of avoiding the impact of the regulations would be to offer someone not a 0 hours contract, but a 1 or 2 hour contract. And that has been addressed in these draft regulations, and that would be outlawed. So you can't just offer a low number of guaranteed hours. Interestingly as well, they've fixed the earnings bar at £20 per hour. So if you earn £20 per hour or above, then, or one of your casual workers, then they will not benefit from the protection under these regulations. And that equates to around about 41,000 as a base salary for a full-time employee. The draft regulations allow for the possibility of employment tribunal claims if there's a breach, and that includes detriment claims. So if someone feels they are being disadvantaged by you because they are working for a third party, then they can bring a detriment claim in the tribunal. And the regulations allow tribunals to impose financial penalties on employers who continue to use exclusivity clauses or take any of these avoidance measures. So if this does become law, which it looks like it will do, then I think the first point to note is actually this £20 bar isn't actually that helpful, because research shows that most workers on 0 hours contracts earn less than £20 an hour. So this is going to cover most casual workers on these kind of contracts. Now, one thing I would say is the reason people tend to put these exclusivity clauses in the contracts is to prevent competition. So if that's a particular concern for you and you're having to take exclusivity clauses out, then you need to make sure you put other forms of contractual protection in the contract to restrict competitive activity. I wouldn't go as far as removing 0 hours contracts altogether from your arsenal, because actually, as we've said, employees do seem to quite value the flexibility of 0 hours contracts, so actually it might not be that helpful. It might in fact be completely unwanted to remove them altogether. But I think one of the biggest areas of risk, should this become law, will be the detriment claim. And the way I see this working is, if you take the exclusivity clause out, someone goes and works for a competitor and then you don't give them as many hours, then they will say, but the reason I'm being disadvantaged on my hours is because I'm going to work for a third party, and that is a form of detriment. And so I think we're going to have to look at strategies for ensuring a fair distribution of work, or at least being able to justify why work has gone to one person as opposed to another, to avoid that detriment risk. Now, no date has been set for implementation of these regs. Query whether it's going to be possible to have them implemented before the election now, and if, of course, there's a change in government, query whether it will become law at all, although from what I can gather, most of the main parties are in support of this legislation. Okay, I want to move on to the topic of varying contracts of employment, and the case I'm highlighting here is Norman and the National Audit Office. And the particular issue that this case looked at was whether you can use a general flexibility clause in a contract of employment to change specific terms, and here the terms were additional leave entitlement and sick pay entitlement. And when I say general flexibility clause, I just mean a clause that's tucked in at the end of the contract that just says something along the lines of, these terms are subject to amendment from time to time by notice in writing. So totally vague and non-specific. And in fact, in the National Audit Office case, it was even more vague and non-specific than that. It just said the terms and conditions of employment are subject to amendment. And that was all it said. If an amendment was going to be made, it would have to be in writing. Now, the background to this is that the National Audit Office wanted to introduce changes to additional leave and sick pay entitlement. They consulted with the union, PCS, about this, but the union refused to agree to the change voluntarily. And so the National Audit Office just decided to proceed with the change regardless. Said we've got the right to make these amendments, look at that particular clause in the contract. We're notifying you of the change in writing. It's going to happen in X number of weeks' time, and that's the end of it. The employees said that this purported change was actually a breach of contract because the National Audit Office couldn't rely on that general flexibility clause, and so they were seeking to impose a change in contract which wasn't agreed to. And so the employees sought a declaration that their terms and conditions of employment remained unchanged. Now, when this case first went to Tribunal, the Tribunal actually found in National Audit Office's favour and said that that general power of amendment was enough to entitle National Audit Office to make that change, and all they had to do was notify the employees in writing of the change. And as we'll come on to, I think the Tribunal at first instance was heavily influenced by another case, the Asda and Bateman case, which we'll look at in a minute. The employees appealed that decision to the Employment Appeal Tribunal. And if we just pause there and think about how you vary contracts of employment, the first way and the easiest way is just to do it by agreement, either with the individual or, if we're talking about collectively agreed terms, to do it with the union. But if you can't do it by agreement, then you might have a look and see whether you've got an express flexibility clause in the contract, and that express flexibility clause will be capable of being relied upon depending on the drafting of that clause. But just a note of caution there, it's always going to be subject to the implied term of trust and confidence. So if we're talking about a relocation provision, it wouldn't be appropriate to tell somebody overnight that you are relocating them from London to Glasgow and telling them that tomorrow that's where they've got to report, even if you've got the apparent flexibility in the contract to do that. Another way of introducing the change would just be for you as the employer to say, we're going to do this unilaterally. The change is going to happen on the 1st of May, and we cross our fingers, and if after a reasonable period of time people haven't objected to that change, then we can say impliedly they've accepted that change, and that's a perfectly valid way of going about things. And then the final way, I suppose the nuclear option really, would be for the employer to terminate the existing contract, so it's actually a dismissal, with an offer to re-engage the employee on new terms. Again, perfectly valid way of doing things. I call it nuclear because it's not a particularly good message to be sending out to the employees that they're being dismissed. And of course, if they've got 2 years service or more, there is the risk of unfair dismissal. The other point to just flag there is the collective consultation risk if you're proposing to dismiss 20 or more employees that way. Even though it's not strictly redundancy in the ordinary sense, it would be a redundancy for the purposes of collective consultation if you proceeded in that way. So those are the basic ways of introducing those changes, and obviously the one that we're looking at here is the flexibility clause route. And there's a significant body of case law out there on flexibility clauses, and the thrust of those cases is that the clause has to be very carefully drafted. It's got to be very specific and targeted for it to be enforceable. Now, we talked about it a moment ago, the Asda and Bateman case. This was a case in 2009 that went to the Employment Appeal Tribunal, and it's authority for the fact that in certain circumstances an employer can rely on a general right to amend terms and conditions of employment. Now, I remember when this case came out being quite surprised at the time, and most of us, most commentators, felt it was a case that was limited to its facts, so it would be a fairly narrow application. And just by way of a reminder, that case related to new pay and work structure that Asda wanted to introduce, which affected 18,000 employees in the UK. They consulted extensively about those proposed changes, and over half of the workforce accepted the changes voluntarily. And then for the ones who refused to accept, Asda imposed the change unilaterally, gave them adequate warning and just said it's going to happen from this day. And the reason we can do this is because the contract, the actual contractual provision was set out in a contractual handbook, and the handbook said that those terms could be reviewed or amended at any time to reflect the changing needs of the business. Now, the reason the Employment Appeal Tribunal allowed Asda to impose that change in that way was because they found that the wording of that power to amend was clear and unambiguous. Asda had reserved the right to review, and they'd reserved the right to amend, and they'd reserved it in circumstances where the needs of the business were changing. And all of those circumstances were met in this particular scenario. And the Employment Appeal Tribunal, I think, was also influenced by the fact that the change that Asda were proposing was reasonable, in inverted commas, and also there was a reasonable amount of consultation that Asda had undertaken before imposing things unilaterally. And I think what we can take from Bateman is probably, at best, its authority for the fact that that general right to amend can be relied on where the change is reasonable and the power itself is clear and unambiguous. And when the Employment Appeal Tribunal looked at the Norman and National Audit Office case in the light of Bateman more carefully, they decided that actually the National Audit Office couldn't rely on their general power to amend. And the reason for this was that the flexibility clause that the National Audit Office wanted to rely on wasn't clear and unambiguous. All it said was these terms may be subject to amendment, but it didn't go as far as to say, and we, National Audit Office, reserve the right to impose those changes on you, and the sort of circumstances when that could be done. And so that was very significant. So I think the Norman case kind of takes us back really where we were. I don't think it goes as far as to say general flexibility clauses just can't be relied on. So it's still worth, if you're looking to change terms and conditions, it's still worth looking to see if you have a general flexibility clause. But I think if you're going to rely on that clause, you need to look at the way it's drafted and make sure it's clear and unambiguous in terms of what can be changed. I think the proposed change itself would also have to be reasonable, and whilst the Employment Appeal Tribunal didn't give a detailed opinion on this, arguably does that mean that detrimental changes would be excluded? I think perhaps it does, although it would obviously depend on the circumstances in terms of what's reasonable. And I think the best advice really is, whilst they're nice to have those general flexibility clauses, still the better approach is the bespoke flexibility clause. So if you want the right to change shift patterns, then expressly reserve that right. If you want the right to change private medical benefits or life assurance or any other benefits, expressly reserve the right each time you refer to a benefit to change it, to withdraw it, to amend it, to use a different provider, be very clear about what it is you're wanting to reserve that right to change. Okay? Move on to unfair dismissal and investigations. Shrestha and Genesis Housing Association is the case, and the issue that that case looked at was how far does an employer have to go to ensure that a disciplinary investigation is reasonable. And the background to the case is all to do with this Birchall test, Birchall and British Home Stores. You've probably heard of that test. For a dismissal for misconduct to be fair, the employer has to satisfy three things. Firstly, they've got to have a genuine belief in misconduct, so mere suspicion isn't enough. That belief has to be based on reasonable grounds, so it's got to be a sustainable belief. And you can't have formed that belief until you've conducted a reasonable amount of investigation. So really what this case is looking at is that third limb, what constitutes a reasonable amount of investigation. Now, previous cases have been quite helpful on this point, and they've confirmed that an employer isn't expected to undertake a police standard investigation. And effectively what we have is a band of reasonableness. What would a reasonable employer do when faced with that particular allegation of misconduct? And importantly, the tribunal can't substitute its own view. It's just got to decide what would a reasonable employer do. Now in Shrestha, the case concerned misconduct relating to unusually high mileage claims. Effectively, the allegation was that Shrestha was defrauding the company by overstating mileage to benefit from that financially. The investigating officer, when confronted with those claims, did a reasonable amount of investigation, you would think, compared claims for particular journeys that were being submitted with similar journeys that Shrestha had made in the past, and spotted a pattern of overstating in the recent claims, and also tested some of them against the RAC website to establish whether actually the earlier claim was inaccurate and that the most recent figures were in fact the correct ones, and found out that the RAC website figures were also significantly lower. So the investigating officer was satisfied that there was a pattern of overstating the mileage claimed. So the case proceeded to disciplinary hearing, and Shrestha's defence at the disciplinary hearing was that yes, additional mileage was incurred, but there were very good reasons for this. You know, things like if you have to avoid a one-way street, it takes you out of your way. You're not just travelling as the crow flies, so that puts on mileage. And then it doesn't allow for things like roadworks and diversions where actually you might decide to take a longer route than normal because overall it's going to be quicker. And that was the thrust of his defence. Now, faced with that defence, the disciplining officer had a decision to make. Does he stop and carry out further investigations, or does he just proceed? And he decided to proceed, and in fact proceeded straight to dismissal. And the reason he took that decision was that he thought the explanations were implausible. He thought, even if you accept one-way routes, roadworks, diversions, it wouldn't account for the additional mileage and the extent of the additional mileage. He also thought that even if that wasn't the case, and that in some cases you could account for it that way, it wouldn't be the case with every expense claim, because it would be highly implausible that there'd be roadworks and diversions on every single journey being claimed for. So on that basis, he proceeded to dismiss. Shrestha challenged the fairness of the dismissal, focusing on the extent of the investigation. And he said that what happened is that the employer obviously did what they did, but that the tribunal should have looked at what the employer Genesis failed to do as well when reaching their decision on whether this dismissal was fair. And what Shrestha was saying was that essentially they should have stopped and they should have looked at every single journey to find out whether roadworks, diversions, etc. applied. And because they didn't do that, it wasn't a thorough and reasonable investigation. Helpfully, Court of Appeal rejected Shrestha's argument and said that what matters when you're applying that Birchall test is the reasonableness of the investigation as a whole. So a forensic investigation of every single journey wasn't required in this particular case, and the tribunal was perfectly entitled to find that the extent of the investigation was reasonable. So I think this is a helpful case, and it, as much as anything, it reaffirms that what's reasonable in the context of an investigation is a relatively low hurdle. It's not forensic investigation, it's not police standard, it's just what's reasonable in the circumstances. But, quick note of caution, don't take this case as authority for the fact that you can just completely disregard and overlook an employee's line of defence. I think the approach you should be taking, if you're faced with a particular line of defence, is to ask yourself, is it reasonable to conduct any further investigation before I take this decision? And if it's not, make sure you can explain why it's not reasonable. And probably documenting that as part of your thought process, whether as a separate file note or even as part of the dismissal letter, would be useful evidence. Okay? So the final topic to look at is tribunal statistics. And you'll be aware these are very much in the spotlight at the moment, and we've just had out the figures for the final quarter of 2014, so that's September to December 2014. And whilst tribunal claims are slightly on the up again, they are still, according to these statistics, 57% down on what they were in the same period in 2013. Okay, so that's a significant overall reduction in claims, and clearly this is linked to the introduction of the fees regime, and that's part of the basis why, of course, the fees regime is still being challenged. But whilst we've got this fees regime in place, I think that the important question that we as HR professionals and employment lawyers should be asking ourselves is, does this actually present us an opportunity to take some bolder decisions as far as employment law is concerned? And where I'm going with this, I think the most common question I think a business will ask, probably you or me, if they're contemplating dismissing someone, is what's the risk? And it's all too easy when you're answering that question to go down a set track and ask yourself the same questions. So we focus on what are the merits here, you know, what kind of evidence have we got to warrant a redundancy situation or a misconduct dismissal or a performance dismissal? What are the legal issues, the legal framework? Are we going to win a tribunal claim? What's the potential compensation? You know, this is a long-serving employee. Will they be able to mitigate their loss? What are the legal costs, the management time, the adverse PR? All those factors are brought into the equation to determine what the risk is of dismissing the employee. And I think these are all still very, very relevant questions and still have to be considered as part of the overall risk profile. But I think there's an important question to ask before any of those factors come into play, and that's, what is the risk of a claim actually being brought? And if we focus on that question first, then it may well be the case that we conclude that in the light of these statistics, where we're 57% fewer claims than we did this time last year, that a claim is actually very unlikely to be brought at all. And that would certainly be the case, it seems to me, if the claim is of low value. So I think what I'm saying is it's a percentages game, and the percentages are stacked at the moment in our favour. So I'm kind of exploring whether we can use this to embolden us to take some more robust decisions, and I'm thinking that now might be the time to take that kind of action, not least because the current regime may not last if there's a change in government, because of course the Labour Party have said in particular that they would review the whole tribunal system, including the fees regime, and so actually the percentages may not end up in our favour after all, after the election. So I think it's a good time to think about taking those slightly difficult decisions, and I know I'm working with some of my clients to do just that at the moment. Okay, that brings us to the end of the formal presentation. I'm happy to stay online for a couple more minutes if people want to post any additional questions. Otherwise, by all means, feel free to dial out at this point. Keep an eye out for your invitation to your next People Hour session. Usually they're on the first Tuesday of the month. This one was slightly different because of Easter, so we'll be the first Tuesday in May for our next one. And we look forward to seeing you there. In the meantime, look out for People Matters as well, our email alerts on employment law changes. So I'll leave matters there. It seems that there are no questions, so I'm going to stop this presentation now and look forward to seeing you at the next one. Thank you.